this as if I were to file it in the Supreme Court of the state of New York, and then they would put a case number. And then how the petitioner is, I put Anthony, a man, incarnate living soul, and exclusive user of Anthony Rubio as petitioner. Against State of New York Corporation, against Mark Fleischer as Director of Administrative Services of New York Health Department, Andrew Como as Governor CEO of State of New York, Thomas D. Napoli as Comptroller of State of New York, Eric T. Schneiderman as Attorney General of State of New York, and they're the respondents. Now, please understand, I'm anything but a lawyer. I don't understand a lot of this, so whether that was correct to name them all, or it was just Andrew Como, or the Director of Administrative Services from the State of New York Health Department, who knows? Again, I haven't really gotten to my studies. I'm not looking to file a lawsuit. I think that would require a whole new set of understanding. You also have to remember that the court requires to get jurisdiction the name in full. So when I'm acting as a petitioner and I'm only using the given name as opposed to the factitious entity, the court may throw it out just on that term. You just, really, who wants to answer this? Are you working in fraud? Are they unconscionable contracts? Is it misrepresentation? You know, I mean, what are they going to answer? Hello, it's a private system. So I get all this, and it's not that I'm making a claim that it's private or it's I mean, I don't understand. It's clearly the state of New York retains the original birth document or certificate of live birth, or you want to call it an instrument or a document, record, deed. They retain it. I can't get it. So what that suggests to me is that it's their property. And I actually got Guy Warner, who's the director of Vital Statistics. I had a half-hour conversation to him, and I said, why didn't you answer my letter? He says, why should I? But eventually he did slip and say, and of course this would be considered hearsay in, I guess, a court of law, that the name is title to a property. So, you know, we think it's our name. Well, it clearly is not our name, and every time we say I am so and so, that equals under their rules, which is quite deceptive, but they're allowed to be deceptive under rules of war on land, if you go back to the Libra Code, and I think it was also in the Law of Nations, if I remember right. But anyway, I'm rattling on, but it's important we get a clear understanding. So continuing on with this draft sample of a declaratory judgment, what I'm looking for, it's continuing on, a memorial for declaratory judgment demanding clarifications of duties and rights of a man and his relationship to a state of New York birth record or registered organization in regard to the name, property, estate, person, individual, factitious entity, etc., Anthony Rubio. And then under that I put, I, a man, the petitioner, come to the Supreme Court in peace and in support of the United States. And why I do that is I want it very clear. I'm not looking to be a smartass. I'm not looking to harm anything. I just want to really get what is my relationship and my responsibilities to this. What is my benefit? I get to use Federal Reserve notes? Fantastic. What does that mean? Well, everything I use has a lien on it. You know, whether it's a house or a car, I don't own it. The state owns it. Well, I don't have a problem with all that. God bless them. If they think they need all that paper and stuff, and that helps them with their funding of the government, fantastic. I have no problem with that. But then there's something called usufruct, and that's part of their rules, and it doesn't seem they want to do their end or their responsibility. So anyway, continuing on. Petitioner moves this court for a declaratory judgment and or order and declaratory relief concerning the legal relationship, status, rights, and duties upon petitioner. And then I do a table of contents, and then in that it's an overview. Next item, individual respondents are public officers. Next item, individual respondent, public officers are fiduciaries of the public trust. Next item, jurisdiction. Next item, cause for demand. Next item, claim for relief. Then I go back over the introduction. Overview. Firstly, in petitioner's opinion, this procedure is both an unfortunate and an unnecessary, continuous, multiple effort on petitioner's part to have multiple questions addressed with regard to the name Anthony Rubio. See Exhibit A, hereto attached, incorporated and referenced. Having had ample opportunity to address this matter, the named respondents have decidedly chose to remain silent, thus creating an intentional controversy. Petitioner agrees that any corporate, governmental agency or trust always has jurisdiction over its property, or specifically, in this case, the name Anthony Rubio. Petitioner is the exclusive user of the property or name Anthony Rubio, appearing to be owned by the state of New York, whereas the state of New York, through its public trustees and or authorized agents, had sent petitioner a certified copy of the birth record, evidencing intent on the part of the state of New York for petitioner's apparent exclusive use with an intended purpose. At no time were any instructions, list of benefits, or obligations, warnings, or the like sent to petitioner when this certified birth certificate was issued specifically to petitioner. This intended purpose and such consequences are the issues to be discussed, clarified, and adjudicated by the Supreme Court as exactly what is petitioner's relationship, rights, and duties to this name and intended purpose of the state of New York to issue a certified copy of this document to petitioner. Based on this clarification from this Supreme Court, hopefully petitioner will be able to move forward more freely with petitioner's life, liberty, and pursuit of happiness. At this time, petitioner cannot exactly call this a claim per se, as petitioner has no clue to how the Supreme Court will address this issue. The options for possible relief that the petitioner sees as possibilities will be discussed toward the end of this document. Petitioner believes that there may be a national security issue potentially at risk with respect to this controversy. Therefore, the matter can be discussed in camera or in public forum. Petitioner has no preference. Petitioner assumes that this matter could be simply addressed in writing and by telephone without formal public forum. The ultimate, because again, I'm down here in Florida, and this is New York State up in Albany, I guess, or wherever. Yeah, they would have that Supreme Court up there. The ultimate question to be responded to by the respondents through the Supreme Court will be, what is the petitioner's relationship to the person, Anthony Rubio, and the legal duties and rights associated with the operation of a state agency or name? What is the petitioner's status in relationship to the state of New York at law? If the state of New York is within the jurisdiction of the United States, how does this affect the issue of status? You realize what I'm asking, I hope. What is the construction of the instrument or document, birth record, certificate, and the facts surrounding its creation? What is the legal authority or legislative reference to use a name for personal identification? What is the significance of authenticating the official act of Guy Warner by the state of New York and the United States of America? Department of States entitling full faith and credit to said official act by said public trustee deemed authorized as a proper officer performing his official duty under the state of New York with regard to the birth record. Secondly, petitioner suspects there is a discomfort to respond to this matter honestly and completely, as petitioner does presume from the many letters and or notices petitioner had sent out previously registered or certified mail to various public officers or trustees. None were responded. However, in petitioner's opinion, this is no excuse not to respond intelligently, completely, and honestly to this matter. As petitioner would guess, even under the rules of war on the land, under a declared national state of emergency, public trustees or officers have a code of honor to be followed, even though it appears under the rules of war on land. And I'm quoting, it admits deception but disclaims acts of perfidy, and in general military necessity does not include any act of hostility, which makes the return to peace unnecessarily difficult. And that's from the Libra Code, Article 16. To the best of practitioner's understanding and willingness, in good faith, practitioner wants to support the United States during the seemingly unending declared national state of emergency, and aid, help, assist, or bring about the return to peace to current and future generations so they can attempt to have abundant life, liberty, and the pursuit of happiness. However, petitioner takes notice that this peace cannot take place until, and it's number 2 of the Libra Code, martial law does not cease during the hostile occupation except by special proclamation, order by the commander-in-chief, or by special mention to the Treaty of Peace, concluding the war when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. Moving on. Petitioner has publicly recorded and demanded responses from public trustees on numerous issues, but petitioner has not received responses. One such area is hereto attached as Exhibit B. Thirdly, it is most difficult to address this matter in a one-way dialogue, since petitioner has no clue as to the Supreme Court or respondent's response, lawfully or otherwise. You like that otherwise part, huh? It seems to be the otherwise that could be an issue. Petitioner has absolutely no legal training whatsoever, nor does petitioner speak legalese. However, the respondents reading this do have knowledge, or should have knowledge in this matter, and there can be no excuse not to provide a direct response to these questions at hand and provide relief. The intent and questions are clear, even if petitioner misspelled some words or does not exactly have the entire legal scenario 100% all perfect. Petitioner was not able to read a book, for example, What is the Real Meaning Behind the Birth Certificate for Idiots? This study, trying to put the pieces together as best as petitioner was able, took years, and clearly petitioner does not have all the legal pieces together. It appears the name, Anthony Rubio, really has nothing to do with the petitioner other than the mere exclusive user, where everything done in that name benefits the state of New York as title holder and or the United States as beneficiary, and not the petitioner. It appears petitioner has been left naked or spoliated. Petitioner thereon believes and alleges that it has been most disturbing to encounter a tidbit of information in attempting to understand the rules of war under domestic and international law. It is almost difficult to imagine U.S. citizens as vessels can be considered legally enemies of the state from the amendment of the Trading with the Enemies Act and are nothing more than unaware consenting sureties through operation of law for a public debt under some admiralty jurisdiction. Everything is UCC under martial law rule. Courts are mere military tribunals administrating public policy statutes. However, after much study, petitioner has come to peace with this martial law rule and a willingness, to the best of petitioner's current understanding, to release and surrender any potential presumptive claim and or reversionary interest of said property or estate or name in good faith to and for the account of the United States as usufructuary. It is not a correct protocol for the state of New York to recognize Oh, is this not a correct protocol for the state of New York to recognize, then act as title owner of the individual estate or name Anthony Rubio, to settle, acquit, and discharge claims for Anthony Rubio by and through the state of New York, comptroller, governor, or attorney general as the principals of the state of New York property? Those with higher level public officer or trustee titles, as those listed above, were able to put the pieces together and provide answers or relief, or provide some higher ranking officer who can. Petitioner would imagine it is all the laws that public trustees are required to uphold, and not just the laws that work best under the 14th Amendment, Section 4. Which of course you realize is they get a piece of the action in suppressing insurrection or rebellion against the United States, and as soon as you make a claim to the name, I am so-and-so, that gets their jowls seething, salivating for, they get to dip into those Sestakay trust funds. Do I really know how it works? No. Do I really care? No. Do I really want to know? No. All I really want to know is, why am I a presumptive surety bitch for their person? And they benefit for it. And then I get the bill, supposedly. But in reading on, however, petitioner does reserve the right to bring up areas of law that appear to specifically apply to public trustees in their performance of their duty under the public corporate trust. As far as petitioner understands, none of these public policy laws apply to petitioner whatsoever. If any or all of these public policy laws do apply to petitioner, however, here is the Supreme Court and/or respondent's opportunity to counter this statement and prove it. How do you like that? It seems to petitioner that these public policy laws only apply to elected officials and/or employees on the payroll, and of course on the payroll should be stressed, of the public corporate trusts in performing authorized duties on behalf of the corporate trust, as said trusts appear to be commonly called governments, states, counties, villages, towns, and cities. Fourthly, FYI, petitioner came to this endeavor through spiritual study first, and then it was through that study that it naturally progressed to this exercise of petitioner's relationship to the person. All of the Creator's creation is subject to the royal law. This includes public trustees. Whether this court agrees with this or not is not petitioner's business. In petitioner's opinion, we are commanded under the royal law to do and not do certain actions. The Creator is the supreme authority of His creation, inclusive of all incarnate souls appearing in living and breathing form. Therefore, the ultimate questions to be determined by this Supreme Court will be, how has any authority been conferred, derived, conveyed, deeded, transferred, or assigned to any man or group of men over another man, regardless of operation of man's law? How does one man or group of men seize, confiscate, take by operation of law or by necessity another man's unalienable natural inherent rights, his property, freely given by his Creator? If by operation of law consent is presumed or required, then this question to be answered by the court is, how does one remove the presumption or unconsent to some unrealized presumption or contract? How does a man enforce contractual oath-bound duty agreed by public corporate trustees under martial law rule in performance of fiduciary duties according to law without falling prey to a jurisdictional pitfall as a person where such title to the person is held in trust by the state? Then the next caption is, individual respondents are public officers. Continuing, the individual respondents listed with their official titles are public officers, and as such are fiduciaries of the public trust created by the Constitution of the United States of America and the Constitution of the State of New York. Therefore, it is believed and thereon alleged that 1. All fiduciaries of the public trust, public officers, owe loyalty to the constitutions which created the public trust and are required to be bound by